We now move on to one more wrinkle of the confrontation clause, issues with codefendant confessions. This is man. This is dude. Man and dude are co-defendants in a criminal trial. If man testifies in court, dude's counsel can cross-examine him. This raises no confrontation problems. Watch. And vice versa, of course. If dude testifies at trial, man can cross-examine dude. But what happens if man made an incriminating out-of-court statement which implicates dude? If man won't testify, dude won't be able to cross-examine him. This is a confrontation violation. The statement cannot be admitted against dude. But what if we admitted man's statement at the joint trial only against man, warning the jury to disregard the statement insofar as it applies to dude? You probably have a gut feeling that this is not going to work. The statement cannot be admitted, even if it's limited only against man. This is what the Supreme Court decided in Bruton versus United States. The logic is the jury instructions won't be followed and there's too much risk of prejudice. The court wrote, "There are some contexts in which the risk that the jury will not or cannot follow instructions is so great and the consequences of failure so vital to the defendant that the practical and human limitations of the jury system cannot be ignored. Such a context is present here, where the powerfully incriminating extrajudicial statements of a co-defendant who stands accused side by side with the defendant are deliberately spread before the jury in a joint trial. Not only are the incriminations devastating to the defendant, but their credibility is inevitably suspect. The unreliability of such evidence is intolerably compounded when the alleged accomplice, as here, does not testify and cannot be tested by cross-examination." Would it change your answer if you found out that both man and dude had made out-of-court confessions and the confessions interlock? Essentially, both versions incriminate both man and dude. In this kind of scenario, a possible argument for admissibility might be, well, since dude has already given an out-of-court confession, surely man's out-of-court confession cannot harm dude more than dude has already harmed himself. But consider the argument on the opposite. The Supreme Court was unable to authoritatively resolve this problem in Parker versus Randolph. But in Cruz versus New York, the court decided that the out-of-court confessions of both man and dude were inadmissible. The logic behind this is that it is precisely the interlocking nature of the confessions that actually makes things worse for dude. Justice Scalia wrote, "It seems to us that interlocking bears a positively inverse relationship to devastation. A co-defendant's confession will be relatively harmless if the incriminating story it tells is different from that which the defendant himself is alleged to have told, but enormously damaging if it confirms in all essential respects the defendant's alleged confession. It might be otherwise if the defendant were standing by his confession, in which case it could be said that the co-defendant's confession does no more than support the defendant's very own case. But in the real world of criminal litigation, the defendant is seeking to avoid his confession on the ground that it was not accurately reported or that it was not really true when made. It seems to us illogical and therefore contrary to common sense and good judgment to believe that co-defendant confessions are less likely to be taken into account by the jury the more they are corroborated by the defendant's own admissions, or that they are less likely to be harmful when they confirm the validity of the defendant's alleged confession. Far from carrying Bruton to the outer limits of its logic, our holding here does no more than reaffirm its central proposition. This case is indistinguishable from Bruton with respect to these factors the court has deemed relevant in this area: the likelihood that the instruction would be disregarded, The probability that such disregard will have a devastating effect, the determinability of these facts in advance of trial. You can already sense that there's an easy solution to this problem. And that easy solution is something we've already reviewed in a previous lecturette. Sever the trials. In that case, you can offer each defendant's out-of-court confession against that defendant only. Alternatively, you could offer one of them, for example, man, a plea bargain that requires him to testify against dude at dude's separate trial. But severing the trial isn't always possible for various logistics and financial reasons. So how about a solution that could be a little bit more complicated and maintains the joint trial? What if we were to admit a redacted version of man's statement at the joint trial only against man? There are a few ways to do this. Some of them are constitutionally permissible and some are not, depending on the way that the editing is being done and the extent of the resulting prejudice. Here's an example from a case called Richardson versus Marsh. The original statement was something like, dude and I robbed a pizzeria together. I held the bakers at gunpoint and dude drove the getaway car. Consider this redacted version. I held the bakers at gunpoint during the pizzeria robbery. Do you see how the reference to dude has been avoided? Because this omits all references to dude, it's outside of Bruton's scope and therefore permissible. Or consider the following example from Gray versus Maryland. Again, let's assume the original statement was, dude and I robbed a pizzeria together. I held the bakers at gunpoint and dude drove the getaway car. Here is the redacted statement. Deleted and I robbed a pizzeria together. I held the bakers at gunpoint and deleted drove the getaway car. This redaction was deemed in Gray versus Maryland to be inappropriately prejudicial. Can you see why? Here's what the court said in Gray. A juror somewhat familiar with criminal law would know immediately that the blank in the phrase, I, Bob Smith, along with, robbed the bank, refers to defendant Jones. A juror who does not know the law and who therefore wonders who the blank might refer to need only lift his eyes to Jones, sitting at the counsel table, to find what will seem the obvious answer, at least if the juror hears the judge's instruction not to consider the confession as evidence against Jones, for that instruction will provide an obvious reason for the blank. A more sophisticated juror, wondering if the blank refers to someone else, might also wonder how, if it did, the prosecutor could argue that the confession is reliable. For the prosecutor, after all, has been arguing that Jones, not someone else, helped Smith commit the crime. As you can see, the admissibility of a redacted statement is case-specific and depends on the degree to which it is prejudicial. Consider a situation where man, dude, and bro are being jointly tried for the pizzeria robbery. Man's original out-of-court statement said, deleted, and I robbed the pizzeria. We already know that this redaction is not allowed because the two deleted spots are going to direct the jury to look directly at dude and bro. But what if man were to say, a few guys and I robbed the pizzeria? What if the prosecutor took man's out-of-court statement implicated dude and bro and redacted it in that way? A few guys is more vague than two deletions that automatically direct attention to dude and bro. This kind of redaction would be permitted. In short, here are our takeaways about co-defendant confessions. A defendant's out-of-court confession is inadmissible in a joint trial against the other defendant and against the defendant who made the confession. And this is true even if there are more than one confession and the confessions interlock. The possible remedies are to sever the trial, simple, clean, but not always cheap, or to redact the confession in a way that does not change the meaning of the original statement and at the same time does not create undue bias against the person whose identity is redacted.